Every single day I meet with people in my law practice who come to me with a wage garnishment stemming from a judgment that, until now, they had no knowledge of. In order to garnish wages, it's generally necessary to file a lawsuit against the person owing the money and obtain a judgment against them before any type of garnishment can occur. This judgment is the document that gives the debt collector the power to garnish wages or levy bank accounts. In over 90% of debt collection lawsuits filed by junk debt buyers like Midland Funding, Portfolio Recovery, Cash LLC, and Cavalry SPV, the case ends in a default judgment. This means that the consumer, i.e. you, did not file a written response with the court. The reason most of the people I meet with say they didn't file an answer is because they don't have any recollection of ever being served with the lawsuit by a process server. They didn't know about the lawsuit, didn't file an answer, and a default judgment was entered. If this has occurred, there are options and even the possibility of getting the judgment set aside or vacated. I believe people when they tell me they don't recall ever being served with a debt collection lawsuit. For most people, when a process server comes to the door and serves you with a lawsuit, it's a pretty big deal. Most people are stressed out of their minds by this and would clearly remember it if it actually happened. So how does the debt buyer get a judgment if you weren't served? The answer can be found in a document called the Certificate of Service or Affidavit of Service. After the process server drops off the summons and complaint or serves you, they are then required to file the Certificate of Service outlining how you were served, when you were served, who was served, and even provide a physical description of the person that was served. If you have a default judgment, it's important to review the Certificate of Service to determine if they did indeed serve you with the complaint. I've had cases before where the process server alleges to have served the consumer on a specific date, but they were able to prove that my client wasn't even in the state of Arizona at the time. How did we prove it? Facebook. Social media platforms like Facebook, Twitter, and even LinkedIn create a journal of sorts as we chronicle the events of our lives. I have found Facebook to be a handy tool when it comes to determining if my clients were even in the state on the day they were alleged to have been served. I simply have my client compare the date that they were alleged to have been served and the activity on their Facebook page to determine if it was even possible for them to have been served on that particular day. Facebook can be a great resource to show a court that you weren't in the area, didn't live at the address, or that it simply wasn't possible for you to have been served on that particular day. If you can show that you weren't served with the summons and complaint, you can file a motion to vacate the default judgment. And under Arizona law, if service of the complaint and summons was bad, the court does not have discretion. They must set aside the judgment and allow you to contest the allegations brought by the debt collector. Thanks for watching.